judgment in the appeal, the Christian Institute and others, and the Lord Advocate.
Lord Hodge will explain the decision of the court.
This appeal concerns the legality of provisions of the Children and Young Persons Scotland Act 2014, which put in statutory form the so-called named person scheme, which has operated in parts of Scotland for some time. The Act aims to make sure that every child in Scotland has a named person to monitor his or her well-being and be a single point of contact for public services which children and their families can use. It is not in dispute that the promotion of the well-being of children by enabling public bodies to collaborate effectively on their behalf is a benign and worthy aim. It is in any society's interest that families and children should flourish. But 4 charitable bodies and 3 parents who are the appellants are concerned that the legislation involves the state interfering unnecessarily and excessively in family life and disrespecting the privacy of both parents and children. They raised a petition for judicial review challenging the legality of the legislation on the ground that it was beyond the powers of the Scottish Parliament. That challenge has reached this court. The appellant's application has been dismissed in both the outer house and inner house of the Court of Session in Scotland. The appellants have mounted a wide-ranging challenge. That challenge includes the following 3 questions. First, whether the relevant provisions of the Act are matters reserved to the United Kingdom Parliament because they relate to data protection, which is the subject matter of the Data Protection Act 1998 and an EU directive. Secondly, whether the provisions breach Article 8 of the European Convention on Human Rights, which I will call ECHR, and which requires the state to respect everybody's family life, home, and privacy. And thirdly, whether the provisions are contrary to EU law. The central issues are first, the sharing of information about children and young people, and secondly, the role of the named person as the focal point for the sharing of the information about them between public authorities and using that shared information as the initiator of action to promote their well-being. This court, in a judgment written by Lady Hale, Lord Reid and me, unanimously allows the appeal on the second of the 3 grounds, and that is because of the breach of Article 8 of ECHR. To the extent that EU law mirrors Article 8, we hold that it also breaches EU law. We deal first with the challenge that the data sharing provisions of the Act relate to reserved matters. In so doing, we have analysed the complex relationship between the Data Protection Act 1998, which I will call the DPA, and the provisions of the 2014 Act, and have concluded that the latter provisions do not relate to reserved matters and are therefore not outside the powers of the Scottish Parliament for that reason. But that analysis of the very complex relationship between the 2 acts suggests that the powers and duties of disclosure in the 2014 Act cannot be taken at face value and may mislead those who act under the Act and also those who are affected by the powers and duty which it appears to create. Sections 23(7) and 26(11) of the 2014 Act do not allow the disclosure of information in breach of any enactment, and that includes the DPA. But Section 35 of the latter Act exempts personal data from its non-disclosure provisions, where the disclosure is, and I quote in inverted commas, required by or under any enactment. Our analysis of the wording of the 2 acts leads to the conclusion that the 2014 Act, contrary to its appearance at first sight, does not authorise the sharing of what the DPA calls sensitive personal data, which includes data about a person's physical or mental health, sexual life, one's religious and philosophical beliefs, and the commission or alleged commission of an offence, unless one of the relevant conditions of in the DPA is met. Critically, the obligation on the information holder to share information under sections 23(2) and 26(1) and 3 if he or she is of the view that the information is likely to be relevant to the recipient's exercise of statutory functions, does not meet the DPA's condition that the processing of the data is necessary for the exercise of statutory functions. Thus, before the sensitive personal information can be shared, one of the conditions in Schedule 3 to the DPA, such as obtaining the express consent of the data subject or the disclosure being necessary to protect the data subject's vital interests, must be met. Similarly, the power to share data in Section 26(8) must meet the conditions of the DPA. This complex interrelationship between the two acts gives rise to a major difficulty, which is relevant to the second challenge involving human rights. That challenge is founded on Article 8 of ECHR, which, as I have said, gives everyone the right to respect for family life and privacy. The court does not accept the appellant's broadly based challenge that the compulsory appointment of a named person to every child is a breach of Article 8 rights unless the parents have consented or the appointment is necessary to protect the child from serious harm. But the court upholds the narrower challenge in relation to the information sharing provisions of the 2014 Act. In our assessment of this challenge, we pose and answer 4 questions. They are, first, what are the interests which Article 8 of ECHR protects? Secondly, whether the 2014 Act interferes with the Article 8 rights of parents, children, and young persons. Thirdly, whether the interference is in accordance with the law. And fourthly, whether the interference is proportionate, having regard to the legitimate aim pursued. The answer we give to the first question is that the interests include family life. The family is the fundamental group of society which is entitled to protection by the state. This requires the state to allow differences and to avoid trying to standardize children and young people. Article 8 also enjoins respect for their privacy. That privacy extends to the processing of personal data, including medical data, and the law recognizes that the unnecessary disclosure of medical data may deter those who need medical help from seeking such assistance. The answer to the second question is that the Act interferes with the Article 8 rights of parents, children, and young persons in the sharing of personal data, and in particular, sensitive personal data between public bodies. Article 8.2 requires that the interference should be, and I quote, in accordance with the law. This means not only that there is a basis for the interference in domestic law, which there is, but also that the law must be accessible, that is, comprehensible, to the people affected by it and foreseeable in its effects. Applying that to the third question, the court finds that the information sharing powers set out in Part 4 of the Act cannot be taken at face value, and there is a serious difficulty in accessing the relevant legal rules, alongside a lack of safeguards to enable the proportionality of any interference with Article 8 rights adequately to be assessed. In short, Part 4 and the revised statutory guidance do not meet the requirement of being in accordance with the law. On the final question, regarding whether such interference with basic rights can be justified, we consider that the legislation pursues a legitimate aim and that the measures proposed have a rational connection with that aim. It is the question of the proportionality of the application of the Act's provisions in individual cases that causes concern. First, there is a risk that parents will be given the impression that they must accept the advice and services offered, and their failure to cooperate would be taken as evidence of risk of harm. And secondly, the information holder will have to address very difficult questions of proportionality in relation to the disclosure of confidential information in a context in which the proposed statutory guidance is minimal. In relation to the EU law challenge, the court concludes that there is no incompatibility additional to that which we have found in relation to Article 8 of the ECHR. We reach two conclusions. First, the information sharing provisions of the 2014 Act are incompatible with the rights of children, young persons and parents under Article 8 of ECHR. And secondly, those provisions may in practice result in disproportionate interference with those rights, with limited safeguards available to the individuals affected. As presently drafted, they are at risk of placing those tasked with delivering the scheme on the ground in breach of important regulations protecting privacy and confidentiality. The only option open to this court is therefore to rule that the information sharing powers in Part 4 are not within the legislative competence of the Scottish Parliament. This court therefore proposes to make an order under Section 102 2b of the Scotland Act 1998 to allow the Scottish Parliament and the Scottish Government the opportunity to correct the defects which we have identified. To that end, we invite submission on the terms of such an order within 42 days.
Thank you very much. The court will now adjourn.